company shall hold the first meeting of the Board of Directors within 30 days of the date of its incorporation, and thereafter hold a minimum number of 4 meetings of its Board of Directors every year in such a manner that not more than 120 days shall intervene between 2 consecutive meetings of the Board. In addition, SS1, Secretarial Standards on Board Meeting provide that the Board shall meet at least once in every calendar quarter, with a maximum interval of 120 days between any 2 consecutive meetings of the Board, such that at least 4 meetings are held in each calendar year. Section 174. Subsection 1. The quorum for the meeting of the Board of Directors of the company shall be 1/3 of its total strength or 2 directors, whichever is higher, and the participation of the directors by video conferencing or by other audio-visual means shall also be counted for the purposes of quorum under this subsection. Subsection 2. The continuing directors may act notwithstanding any vacancy in the Board, but, if and so long as their number is reduced below the quorum fixed by the Act for a meeting of the Board, the continuing directors or director may act for the purpose of increasing the number of directors to that fixed for the quorum, or of summoning a general meeting of the company and for no other purpose. Subsection 3. Where at any time the number of interested directors exceeds or is equal to 2/3 of the total strength of the Board of Directors, the number of directors who are not interested directors and present at the meeting, being not less than 2, shall be the quorum during such time. Subsection 4. Where the meeting of the Board could not be held for want of quorum, then, unless the articles of the company otherwise provide, the meeting shall automatically stand adjourned to the same day at the same time and place in the next week, or if that day is a national holiday, till the next succeeding day, which is not a national holiday, at the same time and place. Please read the give explanation/modification/adaption for this section. Section 175. Subsection 1. No resolution shall be deemed to have been duly passed by the Board or by a committee thereof by circulation, unless the resolution has been circulated in draft, together with the necessary papers, if any, to all the directors, or members of the committee, as the case may be, at their addresses registered with the company in India by hand delivery or by post or by courier, or through such electronic means as may be prescribed and has been approved by a majority of the directors or members, who are entitled to vote on the resolution. Provided that, where not less than 1/3 of the total number of directors of the company for the time being require that any resolution under circulation must be decided at a meeting, the chairperson shall put the resolution to be decided at a meeting of the Board. A resolution under subsection 1 shall be noted at a subsequent meeting of the Board or the committee thereof, as the case may be, and Section 118. Subsection 1. Every company shall cause minutes of the proceedings of the every meeting of its Board of Directors or of every committee of the Board, to be prepared and signed in such manner as may be prescribed and kept within 30 days of the conclusion of every such meeting concerned, or passing of resolution by postal ballot in books kept for that purpose with their pages consecutively numbered. Subsection 2. The minutes of each meeting shall contain a fair and correct summary of the proceedings thereat. Subsection 3. All appointments made at any of the meetings aforesaid shall be included in the minutes of the meeting. Subsection 4. In the case of a meeting of the Board of Directors or of a committee of the Board, the minutes shall also contain the names of the directors present at the meeting. In the case of each resolution passed at the meeting, the names of the directors, if any, dissenting from, or not concurring with the resolution. Subsection 5. There shall not be included in the minutes, any matter which, in the opinion of the chairman of the meeting, is or could reasonably be regarded as defamatory of any person, or is irrelevant or immaterial to the proceedings, or is detrimental to the interests of the company. Subsection 6. The chairman shall exercise absolute discretion in regard to the inclusion or non-inclusion of any matter in the minutes on the grounds specified in subsection 5. Subsection 7. The minutes kept in accordance with the provisions of this section shall be evidence of the proceedings recorded therein. Subsection 8. Where the minutes have been kept in accordance with subsection 1, then, until the contrary is proved, the meeting shall be deemed to have been duly called and held, and all proceedings thereat to have duly taken place, and the resolutions passed by postal ballot to have been duly passed, and in particular, all appointments of directors, key managerial personnel, auditors, or company secretary in practice, shall be deemed to be valid. Subsection 9. No document purporting to be a report of the proceedings of any general meeting of a company shall be circulated or advertised at the expense of the company, unless it includes the matters required by this section to be contained in the minutes of the proceedings of such meeting. Subsection 10. Every company shall observe secretarial standards with respect to general and board meetings specified by the Institute of Company Secretaries of India, constituted under Section 3 of the Company Secretaries Act, 1980, 56 of 1980, and approved as such by the central government. Subsection 11. If any default is made in complying with the provisions of this section in respect of any meeting, the company shall be liable to a penalty of 25,000 rupees, and every officer of the company who is in default shall be liable to a penalty of 5,000 rupees. Subsection 12. If a person is found guilty of tampering with the minutes of the proceedings of meeting, he shall be punishable with imprisonment for a term which may extend to 2 years, and with fine which shall not be less than 25,000 rupees but which may extend to 1 lakh rupees. Please read the give explanations modifications adaptation for this section. And 49. Subsection 7. Every independent director shall at the first meeting of the board in which he participates as a director, and thereafter at the first meeting of the board in every financial year or whenever there is any change in the circumstances which may affect his status as an independent director, give a declaration that he meets the criteria of independence as provided in subsection 6.